So the misuse that is happening now of the notification of 2018 is that this checks and balance which were there in the system. Now, what was the check in the system? The check was that under the rules, if you got a permission to do surveillance, you couldn't do it beyond a particular period of time. There was a method of reviewing a permission granted once, and so on and so forth. So whenever a permission was granted, it was subject to, firstly, there was record keeping of a permission having been granted. Somebody had satisfied, the investigating agency has satisfied some senior functionary of the state that this is a case where the surveillance needs to be done. And then that permission was to be taken to the service provider. Here, the investigating agency becomes the service provider also, and becomes the authority which has the power to grant the permission, and it does the snooping without any check, because he's not supposed to even maintain records of from when to when he has done surveillance, of whom, and this information with these investigating agencies are being misused in a very big way in this country today. And I think the government should really rethink on withdrawing this notification of 2018. And also, if any organization has purchased a software on the basis of this notification, that software should also be directed to be impounded, because even keeping that software with them under an unauthorized notification will amount to a continuing abuse without the investigating agency having the authority to do so. So I think it's a very serious inroad on privacy. Privacy has now been held to be a fundamental right, and in spite of it being held a fundamental right, this kind of snooping by investigating agencies without any checks, without any control, without any record keeping of people in position is according to me a dangerous thing for any democracy, and it is something which needs to be deprecated.